Now, Ella, there are some pretty big differences between the legal rights of people in a common law relationship and people who are married spouses. At a high level, what are some of the biggest ways that those relationships are different?
I would say basically it's defined by the Family Law Act, at least in Ontario, where there's a clear legal and default rights that are applicable to married spouses, legally married spouses, that does not include or extend to common law spouses. So you start with Part 1 of the Family Law Act, which is all about property division, exclusion, and the definition of the matrimonial home under Part 2 of the Family Law Act. And for those two sections, we don't consider common law spouses in the definition of what a spouse is. However, having said that, again, we are a nation of judge-made law, which is called common law tradition, and judges have found principles in equity or judge-made law where they allow for division of property between common law spouses through claims such as unjust enrichment, joint family ventures, but those are very difficult to prove, and they do require potentially going to the court to just prove that entitlement. Whereas for married spouses, it's right there in the act, you're entitled to it. And it's a much simpler starting point for property division for married spouses.
So it seems to me one of the biggest differences has to do with the home, which for most people in Ontario and in Canada is the largest asset that they own. In spousal relationships, that's called the matrimonial home, but in common law relationships, it is treated differently. So, Jess, is there anything you want to explain about how it's treated differently? If a couple is married together or living together, not married, one of them owns the home and the other does not, and then the relationship falls apart without any cohabitation agreement, and we'll get to cohabitation agreements a little later, but what would the baseline treatment be in cases like that?
Yeah, absolutely. So it is definitely different. So for married spouses, there is under the Family Law Act what's called a possessory interest in the matrimonial home. So that means that even if the home is owned by one spouse, the other spouse has the right to continue residing there. And then in addition to that, as Ella said earlier, married spouses are also subject to the property division regime, which means that what they're entitled to is it's called equalization of net family property. And what that essentially means is the parties are entitled to share in the net worth that they accumulate as a family, whether that net worth is being accumulated in one person's name or in joint names. Both parties are entitled to share in it. When it comes to common law spouses, they don't fall under the definition of spouse under the property or the matrimonial home sections of the Family Law Act. So they don't have the same possessory rights to remain in the home, and they don't have the same right to share in that net worth that is being accumulated by the family as married spouses do. That being said, and again, going back to what Ella was saying, there are equitable claims that can be advanced, like trust claims in the property, like joint family venture claims. And when those claims are advanced, they can also put a pause on the spouse who owns the property's ability to, for example, evict the other spouse from the home. But it's all much more gray and much more difficult to prove and enforce than it is for married spouses who are just automatically entitled.
Now, Ella, we've only got about a minute and a half left. At a high level, one of these ways to make this claim for the house in a common law separation is through something called a constructive trust. Very briefly, what does that mean?
Constructive trust basically means that you have a beneficial interest, an ownership interest in a property without being named on title. So legally, it's not registered under your name, but through years and years of contribution to capital costs such as mortgage payment, property taxes, home insurance, you now have developed an interest that's akin to an owner's interest because you have been behaving like an owner would do towards that property by maintaining it and preserving it through your financial contribution or as well as through your labor of like maintaining the home, performing repairs to it. Anything that adds value to that home can later on be argued as actions and contributions, whether physical or again by through labor work, to show that through usually a longer period of time, you've now gained an interest. So
Right.
you would have to claim unjust enrichment, which can be remedied by the court finding a constructive trust in favor of that person.
But again, not automatic, something you would have to argue in court, unlike in the case of spouses.